Good evening, everyone. The Taubenschlag Institute on Criminal Law and the Segla Center for Interdisciplinary Research of the Law, which are both centers of this law school, is about to host tonight a very unique event, a conversation between Professor Ellen Dershowitz and Dr. Yoav Sapir. What can I say about Professor Dershowitz that has not been said before? Any superlative that I may use will be an understatement. I will not, however, derive myself from the pleasure of introducing him. Dershowitz started to teach at Harvard Law School when he was barely 25 years old. In the sake of privacy, I will not mention the exact year. 3 years later, when he was 28, he was tenured, the youngest tenured professor at Harvard Law School ever. This record has not been beaten for the last 50 years. Dershowitz is a brilliant scholar of criminal law and US constitutional law. He is the author of more than 35 books, and he published more than 1,000 articles in law reviews, magazines, newspapers, and blogs. He has won more prestigious academic prizes that one can imagine. Dershowitz is, of course, more than a prolific scholar. He is the public figure and a civil rights activist. He is also an outstanding criminal law attorney. He won 13 out of 15 murder cases which he handled, including at least one that I think we all saw on TV. On top of all these great achievements, Dershowitz has one additional role that we all cherish him, especially in this room. Dershowitz, simply put, is the lead defense attorney for the State of Israel and the Jewish people. Thanks for coming, Ellen.
Thanks. Can I give a rebuttal? For those of you who would like to see the other side, go to yesterday's Arutz Sheva and read an article by an extreme right-wing Israeli or American who describes me as a dibbuk and says that I have no right to claim that I'm pro-Israel and I should stop speaking on behalf of Israel because I had the temerity of opposing Donald Trump, the Mashiach, from the point of view of this writer. So if you want to read the opposing point of view, I always like to have two sides of every issue presented.
So,
thanks.
So opposing Trump is a big mistake, but we forgive you for now. And Professor Dershowitz will be exchanging his opinions tonight with Dr. Yoav Sapir. Dr. Sapir is our very own local Ellen Dershowitz. Sapir studied his first law degree here at Tel Aviv University, where he was the editor-in-chief of our law review. In fact, he was my senior editor as well, if you remember. He then clerked for Justice Michael Cheshin at the Supreme Court. From there, he traveled to Harvard Law School, where he received his doctorate degree in law. Sapir teaches courses on criminal law and criminal procedure here at Tel Aviv University, as well as Bar Ilan, Haifa University, and the Interdisciplinary Center at Herzliya. I hope that you remember where you have to teach each time. Sapir is... okay. So Sapir is known as one of the top experts in Israel on criminal law. For more than 15 years, he has been practicing as a defense attorney in the Public Defender's Office. He has led the defense of major cases in front of the District and Supreme Court. Since 2012, he leads the Public Defender's Office as Israel's chief public defender. By now, I'm sure that you realize that Sapir is the right fit to hold the conversation with Professor Dershowitz. So thank you, Yoav, for accepting our invitation, and I also wish to thank Dr. Shai Vosner, who is in charge of this event, and the faculty assistant, Ayelet Avriel, for helping him. And this is it. It's time for me to clear the stage.
Thank you.
Thank you very much, Professor Hannes, for a lovely introduction. And thank you and Professor Wosner for hosting us. And thank you, Professor Dershowitz. It's really a pleasure and an honor that you're here with us.
Well, thank you for inviting me. This is one of my favorite places in the world, in front of students and in front of students at Tel Aviv University. I was lucky enough a few years ago to get an honorary doctorate from Tel Aviv University, at which time the hard left called me a McCarthyite. So have been called a Dybbuk from the right, a McCarthyite from the left. I'm comfortably a centrist liberal, and we'll talk about some of those issues. But thank you so much for inviting me. I look forward to our conversation.
So we're going to spend most of the time speaking about criminal justice issues and in particular defense issues. But since you're going to have a new person in the White House I believe next month,
yes.
With your permission, I will ask you a couple of questions regarding the recent elections, the recent presidential elections.
Sure.
So according to recent reports, Hillary Clinton received more than 2.5 million more votes than Donald Trump. Mm-hmm. And yet, due to America's, some say weird, electoral college system, it is Trump who's going to enter the White House.
Right.
So my question to you is, first, this sounds a little, as I said, weird to Israeli ears. How can someone lose the popular vote and then become president? Mm-hmm. So could you explain a little bit the system
Sure.
and its history or purposes?
Sure, but let me first start by saying a person can be the Prime Minister of Israel, having fewer popular votes than his opponent under your coalition system. Very few countries in the world have direct popular democracy. The United States Constitution was written at about the time of the beginning of the French Revolution, and the framers of our Constitution were terrified of pure democracy and created not a democracy, but what they called a republic. And the original conception of the Constitution was to have brilliant, ethical electors selected by the legislatures of their states who would be wise Platonic guardians and who would select from among candidates the person best suited to become the President of the United States. I'll give you an example. In the early election of 1820 or so, a man named Andrew Jackson, who was a wild man from the West, had made his name killing Indians, and in those days a pretty popular thing to do, was running against the most establishment of candidates, John Quincy Adams, the son of John Adams, the second president of the United States and one of the writers of the Declaration of Independence. And this is a good Trivial Pursuit question. There were 10 million people in America at the time. Guess how many voted in that election 20, 30 years into America's establishment? 250,000 out of 10 million, because you had to be male, white, in many states Christian, a landowner, and had to have a certain amount of wealth and pay a poll tax. And Andrew Jackson won overwhelmingly, 150,000 to 100,000. I mean, much more than the relevant 2% that Hillary Clinton may have won by. But the electors just didn't trust Andrew Jackson. And in the end, John Quincy Adams became president. Jackson called it the corrupt bargain, ran for 4 years against that, and 4 years later won as president, and served with some degree of controversy and distinction. So the Electoral College was supposed to balance the power of large states by giving power to smaller states. It was part of a compromise. It was also part of the slavery compromise, because it made it clear that southern states would have enough electoral influence to make sure that the Northeast didn't always dominate in elections. And it's an anachronism, but to say that Hillary Clinton should be president under our system is like saying that a football team that had the most shots on goal should win, even though the other team managed to score one goal in a disputed call. You have the rules, and under the rules, Donald Trump won the election, to my great distress, but it's a reality. And within an hour after he won the election, I called his assistants and I said, I offer my help 24/7 if you want any assistance on Israel, any advice on Israel, as I've done to every elected president of the United States and every prime minister of Israel. So I certainly recognize Trump as our president, but certainly he doesn't come with a mandate. He got many fewer votes. But to give the devil his due, he takes the position that he would have gotten many, many more votes had he run a campaign in order to win popular votes. So, you can't decide really that she won the popular vote, because obviously they didn't campaign in New York and California. because those were not contested states. What happens under the Electoral College is the campaign is conducted in 7 states. Florida, Pennsylvania, Michigan, Ohio, and several others. And that's where the campaign occurs. And the president and the presidential candidates never show up. And foolishly, Hillary Clinton didn't show up in Wisconsin. She thought she had it wrapped up, and Donald Trump went there 11 times, and he won Wisconsin, which became essential to his winning margin. He will be the president for the next 4 years. As I announced yesterday very controversially, and my Democratic and liberal friends are going to hate it, my greatest, fondest hope is that I will be able to vote for Donald Trump 4 years from now, that he'll be a great president, that he'll surprise me. The likelihood of that is between 0 and 1%, but it's my hope and my goal. And if it does happen, I will jump for joy and be very appreciative. But the American system operates in a non-democratic but Republican manner, and that's the way. I don't mean Republican with a large R, although the Electoral College favors Republicans. Almost every case where there's been a disparity, the Republicans have won.
And the last time that the winner of the popular vote lost the elections was in 2000.
And I was the lawyer. I was one of the lawyers for Al Gore in
right. The Supreme Court actually played a very important role there when, for the audience who are not well familiar with the facts, I believe that the Supreme Court reversed the decision of the Florida Supreme Court that ordered a recount.
That's right.
And you were involved in that litigation, and subsequently you wrote a harsh critique of the court using words that are rarely used to criticize the court, such as corruption, I believe, and calling the majority judges liars.
No, hypocrites, really.
Hypocrites?
Yeah, right.
So what was it that so upset you?
Well, what upset me is that first of all, the vote went along party lines. 5 Republicans voted to stop the recount, and 4 Democrats voted to let it go forward. It hurt the Supreme Court's integrity very deeply. But the interesting thing is that the justices who voted to stop the recount and grant the stay are precisely the same justices who never grant stays, for example, in capital cases. Justice Scalia allows, the late Justice Scalia, who was a good friend of mine, and he and I debated here in Israel some years ago, the late Justice Scalia almost never was willing to grant a stay to prevent somebody from being executed who might have been falsely convicted. And the idea that you apply different criteria for granting a stay in a case where it's irretrievable, a person's life cannot be returned, whereas in the Florida case, what's the harm of letting the recount go forward? Then you can challenge it later. So my view is he was applying a double standard, and in my book, Supreme Injustice, I went through all of the 9 justices and showed how their opinions were completely inconsistent historically with how they voted in that case. And tragically, in that case, every justice of the Supreme Court got to vote for president twice. They get to vote for him when they went to the polls, and they got to vote for him when they voted in the Supreme Court decision. Justice Harlan, who was one of the great conservative justices in American history, the day he got appointed to the Supreme Court, he said he will never again vote in a presidential or any election because he wanted to be completely out of politics. Those days are gone forever. The Supreme Court is highly political, which is why both candidates in this election ran on what kind of a Supreme Court they would appoint if they were to be elected president.
So in this case, you actually argued that they decided according to their political affiliation. And this brings to question the method of electing or appointing judges, which is also very relevant here. So in the United States, it's a very political method. The president appoints judges, and it has to be confirmed by the Senate. In Israel, there are very strong political voices now to make the system more political than it is. The claim is that if the court deals with political issues, then it should reflect better the political map. What do you think about it?
I follow Danny Friedman's writings, and I follow the dispute very closely in Israel, and it seems to me that the Supreme Court ought to be a check and balance on the elected branches of government and not represent the elected branches of government. They should not be popularly elected. I like the traditional method in Israel of selecting judges and justices, of having a committee which has a majority of professionals, that is either Bar Association members or judges, and only a minority of politicians, and I'd like to see it kept that way. But I understand, because as a Supreme Court becomes more political, as it gets involved in issues that affect the daily lives of people, it's inevitable that people will want to have much more of an impact on having the judges selected. When you have countries where the Supreme Court, or like the American Supreme Court for the first century of its existence, or the British Supreme Court, they decide nothing of importance. I mean, for example, the Bill of Rights in America were never part of constitutional adjudication for the first 100 years of our history. So nobody cared who was on the Supreme Court. It didn't affect the lives of individuals. But in America, the Supreme Court decides whether your children can pray in the school, whether your daughter can have an abortion, whether your son can marry his boyfriend, whether health care is constitutional. All of these things matter, so you can easily understand. So when the Supreme Court, with my friends, Aaron Barak, who's next door, you should all be listening to him. I don't know why you're here listening to me. If I had a choice, I'd be over there listening to him. But thank you for being here. I appreciate it. When my friend Aaron Barak and others of my friends on the Supreme Court, Dorit Banish and others, moved the Supreme Court toward more activism, they inevitably created a situation that they should have realized, that the public would want to become more involved in deciding the judges that would decide matters that affect their daily lives. So this was not an unanticipated result. It should have been a fully anticipated result. Will you all please say hello to my wife who just walked in? And so, thank you for coming. If she knew that Aaron Barak was speaking next door, she'd be there too. But so it's not surprising to me that there is a movement. The same movement is occurring in England. As the British Supreme Court this week is hearing argument on the constitutionality of Brexit. And inevitably, you're going to see a movement toward people wanting to have more of an impact, particularly in Britain, where the Brexit vote was an anti-elitist vote, and there's nothing more elitist than judges. So you're going to see a distancing between the professionalism of the court. Also, with the need to have greater diversity. You know, in the British courts, people wore wigs. Why did they wear wigs? Because they all were supposed to look the same, because the law didn't reflect individual personalities. It was a manifestation of some abstract legal principles in the sky that any smart person could equally discern. You know, you can sometimes read some scholars who believe that to this day. Ronald Dworkin, for example, really does believe that there is an inherent kind of justice and legal system that if you're smart enough you can discern. You know, I think it's nonsense on stilts, and Ron and I fought like children about that and other related issues. But if you now want to have more diverse courts, you want to have more women on the courts, which is very, very important. If you want to have more Arabs and Muslims on the court here in Israel, more people of color, inevitably it becomes a more politicized process. So it's a knife that cuts both ways. There are no free lunches. Everything has a cost. And the cost of having a more activist judiciary is you're going to have a more activist populace wanting to constrain the judiciary.
So, thank you. One last question related to the elections, but now delving more into criminal justice issues. And this is actually about American exceptionalism in criminal justice. The United States accounts for about 5% of the world's population, but more than 20% of the world's prison population. Some 2.2 million Americans are incarcerated in prisons or jails, while over 70 million have some type of criminal records. And of course, this phenomena is intertwined and related to America's troubled history with race, where blacks make up about 12% in the US population. They account for about 44% of the prisoners. President Obama, it seems that everybody understood that you went too far. And the Obama administration started doing some things about it, not only the fact that President Obama was the first president to visit a federal prison, that's a symbolic act, but they also tried or started to change.
We've had a few presidents that almost ended up in federal prison, but not as visitors, right?
We had one that actually ended up.
Right. In Israel, when you're asking for a prime minister's cell number, it's not his phone, right? Ehud Olmert is a close personal friend of mine, and I'm going to be visiting him in prison tomorrow, but I've told him that joke too, and he appreciates it, right?
So the Obama administration changed some of the more problematic laws. They announced they're going to phase out on private prisons, and yet the Trump administration, or the established, and especially Mr. Sessions, who's been nominated to be the next Attorney General, is a longtime supporter of the war on drugs. He and Trump claimed, some say incorrectly, that there is a new crime wave sweeping the United States. What do you think is going to happen? What is the fate of criminal justice reform that has started?
Well, great question. Thank you. First of all, I'm thrilled that you use the term American exceptionalism, a term that I don't generally like. And when I'm always asked about American exceptionalism, I always respond by saying, yes, we're exceptional. We have more people in prison. We have more people on death row. We have more crime. We have more guns. American is exceptional in very negative ways, as well as hopefully in very positive ways. And you've emphasized negative American exceptionalism. Our criminal justice system is deeply broken. You don't even know where to begin. First, the easy availability of guns is directly related to homicides. You hear disputes among gun advocates on some of those data, but it's impossible to ignore the fact that when you look at comparable countries or comparable states, and you see incredibly higher homicide rates in the United States. And when you get high homicide rates, you see the quest for more death penalty, you see the quest for more prison terms. When Rudy Giuliani was the U.S. Attorney and Mayor of New York, he had what was called the broken window policy. What he said is, do you want to prevent murders? Arrest people for jaywalking. Not quite, that exaggerates it. But arrest people for small armed robberies or small unarmed robberies, and that will keep the murder rate down. So we then move to 3 strikes, you're out, or 3 strikes, you're in prison for the rest of your life. So we have a disastrous criminal justice system. Let me tell you, it's a full employment program for criminal lawyers. So as a professor of criminal law who taught future criminal lawyers, that was the only good part of it. Our students will never be unemployed because we have such over-criminalization. By the way, I think Israel has over-criminalization too, and in a somewhat different way. I'll give you a fact that probably some of you know. More Israeli public officials are indicted than in most other countries, but the vast majority of them are acquitted. So you have an enormous disparity between Israeli public officials who are indicted and those who are convicted. Any system that has a large disparity with any category of people, that between the indictment and the conviction, is a broken system. A system of justice, a fair system of justice, should have a fairly close relationship. I mean, people ask me all the time, how can I defend guilty clients? The vast majority of, I've had 250 or so clients in my career. Of course the vast majority of them have been guilty. Thank God for that. Would you want to live with a system where the vast majority of people charged with crime were innocent? That might be Iran or China. You want to live in a system where the vast majority of people charged with crime are in fact guilty, and our job is to keep it that way. That's why we defend the guilty vigorously and make sure the government has to cross every T and dot every I and make sure that there's always probable cause and proof beyond a reasonable doubt. But when you have a system of tremendous disparity, 2 things are either operating. Either too many people are being indicted who shouldn't be indicted, or too many people are being acquitted who shouldn't be acquitted. I don't know which operates in Israel, but I can tell you the disparity is very, very great. And of course in Israel, the minute you get elected prime minister, this is not only about the current prime minister, but as soon as you get elected prime minister, Yediot Achronot, Channel everybody is going after not only you, your wife, your children, your dog, and trying to undo elections through media attacks on the incumbent. Now, many of you in this room don't like the incumbent, but the same thing happened with incumbents who you liked. Prime Minister Rabin was thrown out of office because his wife had a tiny little bank account somewhere in the United States. When I think about what happened to both Rabin and Olmert, and I wonder what impact it really had on the possibility of peace, whether or not the peace process might not have gone forward if Rabin had not been initially thrown out of office, if Olmert, who had offered peace to the Palestinians just before he had to leave office, hadn't been enmeshed in allegations and proved allegations, in his case, of corruption, Sharon. I mean, it's so rampant in Israel, and it's a tragedy. It's a great tragedy. Both the corruption and the over-criminalization are tragedy. So both of our countries have problems along these lines. Our country is much, much worse because of the racial issue, and because race is a major factor in every aspect of the criminal justice system. Whether you're going to be stopped, whether you're going to be arrested, whether you're going to be indicted, whether you're going to be convicted, whether you're going to win your appeal, whether you're going to be executed, whether you're going to be paroled early, whether you're going to be recalled if you're on parole and put back in the system. If you do statistical analysis, you find two factors determine these. Both are racial. One is the race of the defendant, and the other is the race of the victim. And that is, white defendants are given far lower sentences when they attack black victims than when they attack white victims. Very few people are on death row today in America for killing black people. You're on death row today if you kill a white person. And that's so distorting in our criminal justice system, which is why my friend Steve Breyer, Justice of the Supreme Court, has been spending so much time trying to raise consciousness about the unconstitutionality of the death penalty as applied in the United States today. I think the Trump election is a setback for criminal justice reform. It's a setback for effective gun control. It will be a setback for a woman's right to choose abortion. It will be a setback for people's right to marry who they love if they're of the same sex. I think we're going to live through a difficult period of time, and the role of lawyers, the role of courts, will be increased. Whenever we have this kind of administration, we, the lawyers, have to work much, much harder to achieve justice. You know, as the Torah doesn't say that you'll get justice. It doesn't even say justice you should seek. It says tzedek, tzedek tirdof, which means it's not going to be there. You have to chase after it. You're never going to catch it. It's an illusory concept. It's always a chase. The struggle for justice never, ever stays won. The pendulum swings widely. Sometimes it swings in direction of justice, sometimes against it. I do not agree with Martin Luther King that the arc of justice always moves toward justice. Anybody who lived through the Shoah, anybody who's lived and watching Aleppo as we speak today, cannot be as confident that the arc of justice always swings more to justice. First of all, we have to make it swing to justice. That's our job. We don't just let it swing. We have to influence it and affect it.
You mentioned the issue of race, and of course this was race played a major role in one of your most famous trials, the Oj Simpson trial. Let me just tell you, I'm not sure if you're aware of that in Israel there are strong claims by Ethiopian Jews that they are being discriminated against by the criminal justice system. Mm-hmm. It was a major issue in their demonstrations and their demands. This claim has support in some data, such as 30% of our juvenile prisoners are of Ethiopian descent, whereas Ethiopian Jews are only 2% of the Israeli
One also
population.
has to look at crime rates as well. You can't just assume discrimination based on arrest rates.
Of course. 25% of our clients in the Central District, juvenile clients, are of Ethiopian descent, and according to our data, they are more likely to get prison terms, and there are also claims of over-policing, improper policing, police brutality.
Sure.
Could you, reflecting on the Oj Simpson case, could you say a little bit more about the role of race in the criminal justice system, and what could be better ways to avoid disparities?
Sure. It's a very, very difficult problem. You know, our country, unlike your country, was built on racism. Our Constitution is built on racism. You know, the way it was structured with all the compromises. Our economy was built on slavery. You can't just end it and assume the problem ended. It's a continuing problem that permeates everything about America, but it's improving. Between 1995, when I was involved in the Oj Simpson case, and 2016, there's been a dramatic increase in the sensitivity of police departments toward young black men particularly. The numbers of killings of young black men have gone down dramatically. And yet, when you look at Black Lives Matter, you would think that it's never been worse. In fact, it's never been better, but it's very bad still. But it's never been better. The improvement has been very, very dramatic. And I was a very strong supporter of Black Lives Matter until it foolishly put in its official platform one country. It singled out Israel and said it was a genocidal country that engaged in apartheid. And I quit. Disassociated myself from Black Lives Matter. I support its program, but I will not be part of any organization that engages in blood libel against the nation state of the Jewish people. What I want to do is create alternatives, to create organizations in America where young Zionists, young Jewish men and women can fight for racial justice, can fight for gay rights, can fight for environmental rights without having to choose between those good causes and support for Israel. Today, with what's called intersectionality on many college campuses, all these claims are created together as an intersection, and all demeaned and insulted and offended groups are attacked by the same group, and they attack, and they mean Americans and Zionists, and we're all lumped together. So we have to disassociate these things and create environments where we can continue to do what Hillel said, Emeina Nili Mili, but if I am for myself alone, what am I? We have to continue to balance our support for other people's rights with our defense of our own rights. And Jews have always been in the forefront of the struggle for racial justice. Jews founded the National Association for the Advancement of Colored People. There is today, though, a big breach between many Jewish groups and some black groups. It began with race-specific affirmative action, and that ended. It turned out affirmative action did not discriminate singularly against Jews. There was a funny story at Harvard when we first introduced affirmative action. There's a faculty meeting with the dean of admissions, and one of the Jewish faculty members, I wish it were me, it wasn't, got up and said, you know, we've noticed that there's been an increase among African American students from 2% to 13%, and at the same time there's been a decrease among Jewish students of the same percentage. And are you taking the African American quota from Jewish admittees? And the dean of admissions said, no, you have to understand that we admit people by region, and that because we admit them by region, we now have to take more people from the inner city, and so the donuts around the inner cities like Westchester and Shaker Heights and all those donuts are being negatively affected. And one faculty member, I wish it was me, but it wasn't, said, Dean, those aren't donuts, they're bagels. And the point was made, and it stopped. And now you see, but there's no relationship between increasing African American acceptances and any decrease in Jewish acceptances. It's worked out very well. I just want to make one point about the Oj Simpson case, if you don't mind, because you asked about it. People think that we won that case largely because of reverse racial discrimination, and there were 9 black jurors, 3 non-black jurors who voted for Oj Simpson just because he was black. What happened, and I was very deeply involved in this aspect of the case because I was always the and lawyer, the and professor at Harvard. I always taught law and science, law and psychiatry, law and literature, law and religion, law and you name it. And so I became very interested in the forensic sciences very early on, DNA before it was very popular. And so in the Oj Simpson case, the major piece of evidence against him was a sock that was found on the floor in front of his bed just hours after the double murder. And the sock miraculously had on it Oj Simpson's blood and the blood of both of his victims. What could be a better piece of evidence? Well, it was a fantastic piece of evidence, except for 3 problems. Number one, there was a video taken before the police came and claimed to have found the sock, and it showed there was no black sock on the white rug. Number two, the blood on the sock, and only the blood on the sock, had a chemical called ETNA, which is an anticoagulant not found in the human body but poured into test tubes to prevent the test tubes from coagulating, which demonstrated that the police, and we know the name of the policeman, Officer Van Adder, had taken the test tubes home with him and poured them on the sock as it was lying flat. And ultimately, how did we prove that? I hope you can see as I sit here. If you splatter blood on a sock as somebody's running through a killing field, let me stand up. If you can hold the mic here, I can show it. It's okay. If you spill the blood on the sock, you will find that the outside of the sock and the second inside have the same mirror images. But you will not find a mirror image on the third side or the fourth side because the leg intervened and the wearer of the sock wore it sufficient time for the transfer that occurred to be a crystallized transfer, not a mirror image transfer. And any blood splatter expert would understand that, and we saw that on the sock. The sock had 4 mirror image blood samples on all 4 sides. And so we were able to prove conclusively that the police tried to frame Oj Simpson. In their mind, they were framing a guilty man. For sure, they knew he did it, and as far as they were concerned. And they also believed that the glove, which was found, which also had blood of both the one victim and Oj Simpson, would be suppressed from evidence under our Fourth Amendment because it was found without probable cause and without a search warrant. So in order to create a new piece of evidence that would replicate the real evidence against him, they created this piece, this evidence of the sock. The jury understood our demonstration, and every single one of the jurors came to the conclusion that sock was a fake piece of evidence. And so there were 3 groups among the jurors, and I'd be interested in your reaction. There was one group, a small group, that said, look, the sock was tampered with, so we can't trust any of the other evidence, and we're going to find reasonable doubt. That's one group. I think everybody here would agree if you came to that conclusion that the rest of the evidence couldn't be trusted, you'd vote for an acquittal. Then there was a third group, I'm going to skip over the second, which said, we don't care what the evidence is. Too many black people have been convicted of murder too often. We're going to acquit this guy. All right, we all agree that would be wrong. So now I'm going to give you the second group, and I'm going to ask you what you would do if you were in the second group. The second group said, we are absolutely certain that this piece of evidence was, in fact, created by the police, that they were intending to frame a guilty person. But we also think there's enough other evidence in the case, if you discount that, to come to a conviction. Johnny Cochran, who was arguing for the defense, said to the jury, don't reward the police for tampering with evidence. If you don't stop the police from doing this in this case, they're going to do it to your children. They're going to do it to your uncles. They're going to do it to your nephews. Send a message. Teach them a lesson. And so I'm going to ask you, if you were jurors and you came to 2 conclusions, 1, 100% certainty the evidence was planted, but 2, there was sufficient evidence without the planted evidence to convict. How many would vote for conviction? How many would vote for acquittal? Okay, we have a hung jury. I think that's what really happened in that case. I don't know how I would vote in that case. It's a very, very close question. Under law, you should vote for a conviction in that case. But it's not racial civil disobedience. It's another kind of taking the law into your own hands. Much more complicated. Okay.
So, fascinating for us because we don't have juries.
Right.
And this is one of the perhaps most obvious differences between our two criminal justice systems or trial systems. I want to tell you two quick stories from my own experience.
Sure.
One in the United States and one in Israel that I think exemplifies the differences when you're having a trial in front of a jury and bench trials. And hear your opinion. So the first, while practicing at the Public Defender's Office in Public Defender's Service in Washington, D.C., I handled a case where a mother was accused of parental violence. She actually locked up her son in a closet, and she was charged with that. And when I got the case, I investigated the facts and the law, and it was clear she was guilty. She actually admitted doing that. She just said it was disciplinary. It was an unruly child that had to be disciplined. Under
the Bible, she could stone him.
Right, but under DC law,
right.
which I checked, there's no defense for parental disciplining. So I went to a more senior attorney at the office, and I told her, look, we have to go to get a plea bargain because the facts are clear, the law is clear. And she looked at me and she said, not quite. What we need is to get one juror who thinks otherwise. We need one juror who thinks that it's okay for a mother to discipline her child. The other, now going back to Israel, the other story is an armed robbery case that I handled. And my client had an alibi, and he said, actually, at the time of the robbery, I was hanging out in the neighborhood with another guy. We were sitting on the railings. We call it barzelim. It's the equivalent of sitting on the stoop, just hanging out. And I said, okay, where can I find that witness? And he said, go to that neighborhood. You'll find him on the barzelim. And sure enough, he was there. And he said, yeah, he was with me that day. I remember that day. And he came to testify. And when he testified, the judge, who grew up in I assume, in a different neighborhood, just couldn't get her mind around the fact that some people hang out in the neighborhood doing nothing. Yeah. And she kept asking me, but what were you doing there? And how is it possible that you were sitting there doing nothing for 3 hours? And I was thinking, maybe if I had 12 jurors, one of them may have had an experience of growing up in such neighborhood, or even passing by, driving by, seeing people just hanging out. I think it exemplifies that on the one hand, you have the more varied experience of jurors that may be better for fact-finding. On the other hand, jurors can ignore the law.
Yeah, no, those are great
So what is your take about fact-finding by laymen, ordinary citizens, as opposed to professional judges?
I think on balance, juries do a less good job fact-finding than professional judges do, on balance. I think the job of the jury is not to be scientists and to find the truth. Remember, the job of the legal system is not to be scientists. If we wanted our legal system to be scientists, we wouldn't say, if a heavy probability favors guilt, you should still acquit because you have to find it beyond a reasonable doubt. Science doesn't require beyond a reasonable doubt. In science, the better argument prevails. So our system is not a search for truth. It's a search for justice. And, even the Bible, Al pi shnayim edim, you need 2 witnesses. That means if you have one extraordinary witness and a video camera under the Torah, that wouldn't be enough. So justice is always a process. And I think the jury system is better for America, and I think the non-jury system is better for Israel. I think every legal tactic or every legal weapon or development has to be looked at integrally through the culture of the country, the history of the country. America is an extraordinarily diverse country. And the idea of a single judge administering justice just isn't consistent with the American style. But it comes at a heavy cost. We get many cases where the judges would do a better job evaluating the facts. But let me give you another example to show you how difficult. In the Olmert case, you may remember the following situation occurred. The prosecution knew full well that one of their major witnesses was dying, and they knew that he might not live long enough to be cross-examined. And they put him on the witness stand. They kept him on direct for a long, long period of time. And then before Olmert had a chance to cross-examine him, he died. So the judge heard uncross-examined, very, very incriminating testimony against Ehud Olmert. And I helped the lawyer prepare that part of the appeal. And the judge, however, said, "Oh, don't worry about me. I'm a judge. I'm not a jury. Don't worry about me. I totally discounted what I heard from the witness. I didn't take it into account in making my decision." Right. That really understands human nature. If you think that any judge is capable of unringing the bell or taking the smell of the skunk out of the jury room once the skunk has been thrown into the jury room, I got a bridge in Brooklyn to sell you. So I really do think that the system here relies a little too much on judges being infallible and able to evaluate what they will take into account and what they don't take into account. Look, justice is imperfect, and one has to pick a system that best suits the characteristics of a country. And I think you have picked a system that works for your country, and we've picked a system that works for us. Take what's going on in Britain today. Britain is the origin of trial by jury. Today, the 12 jurors that sit in most British trials are 12 pieces of furniture. They are moved around by the judge. The judge, if any of you practice law in Old Bailey, know what a judge's instruction is like in a criminal case in Britain. Ladies and gentlemen of the jury, I've looked at the evidence. Let me tell you, you should not find this, you should not find that, you should find this, you should believe this witness, you shouldn't believe that witness. Judges tell juries what to decide. Under American law, if any judge ever put their thumb on the scale of fact-finding that way, the conviction would be reversed. So although Britain and the United States both have trial by jury, they are dramatically, dramatically different. In America, jurors are really free to find facts. In Britain, judges marshal the evidence and really direct the jurors how they should find their facts. So they have trial by jury in form, but not in reality. And in the United States, we have it in reality. So.
There's one question I'd like to ask you, and I know you'll have to excuse me. You've been asked that question probably
Sure.
1,000 times.
Yeah.
Every defense attorney in the United States, I know it's called the cocktail party question.
Right.
I've been asked that question. I am being asked that question on average every week, once a week. You mentioned that most defendants are guilty, and
Sure.
I certainly agree with you that I would like to live in a society where most defendants are guilty.
Right.
So how do you justify to yourself representing individuals accused, sometimes guilty, of the most heinous of crimes?
Right. So, whenever I'm asked that question, usually by an audience member, my response is always, "Oh my God, I've never thought of that. Thank you so much for asking that question. I've been practicing criminal law 53 years. It never occurred to me." Well, obviously, it's occurred to all of us, and it's, very difficult. First case I ever had as a young lawyer, I represented a Jewish terrorist, a young man from the Jewish Defense League. In those days, the Jewish Defense League was protesting the Soviet repression of Jews, and so this young man made a bomb, a smoke bomb, that was planted by the Jewish Defense League in the offices of Saul Urach. It went off. It was not supposed to kill anybody. It ended up killing a young Jewish woman whose brother-in-law was the major contributor to Harvard Law School, and when I was appointed to represent this young man facing the death penalty, the uncle stopped all contributions to the Harvard Law School and said that he would never contribute again unless I were fired. That became even worse when I won the case. And I knew my client was guilty. The evidence was overwhelming. Every conceivable piece of evidence. And he told me. And he said publicly in court. And we won the case. because they had obtained his confession and his cooperation through unlawful means. And it was an awful feeling to have my client walk out of court knowing that he had the blood, even though he didn't intend to kill. Nonetheless, it was his act that caused the death of a terrific young woman. And it's awful. It's even worse, however, and I've had this case where I've had two young boys on death row who I knew for absolute certain were innocent. And I lost initially in the Supreme Court in a 5-4 decision. And believe me, I lost more sleep over losing a case in the Supreme Court for two innocent boys who cried on the phone to me every night. They didn't want to die. I had nightmares. They were going to be subject to the gas chamber. And I had nightmares of them screaming as they were going into the gas chamber for me, and could I get them out of the gas chamber? Ultimately, we won the case, thank God, and we were able to get them the death penalty eliminated. But you know, when you're a criminal defense lawyer, you lose sleep both ways. When you defend the guilty or when you lose on behalf of an innocent person. But remember that when a guilty person is acquitted, that's part of our legal system. Better 10 guilty go free than 1 innocent be wrongly confined. It all comes, of course, from the story of Abraham and Sodom. Chalila lacha hashofet kol haaretz lo yaseh mishpat. How dare you, God, the judge of all the world, will not do justice? What if there are 10 innocent people among the guilty? Abraham stops at 10, of course, which is where the concept of better 10 than 1 comes from historically. So the acquittal of the guilty is part of our system. The conviction of the innocent is not. Anytime an innocent person is convicted, the system has absolutely failed. And I think probably I speak for both of us when I say our job and our goal is to make sure that no innocent people are put in front of the justice system. That used to be my justification. And I used to think that everybody who was charged with crime, virtually everybody, probably was guilty, until I finally had a case where I knew with 100% certainty that my client was absolutely innocent of what he was being accused of. And who was the client? Me. I was accused of having sex with a 16-year-old girl who I had never met, never heard of, didn't know, had never been with, touched, or even seen. And so, you want to switch mics? Sure. And so I had to defend myself against these scurrilous charges which were made against me for financial benefit. It was part of an extortion plot against Leslie Wexner, the owner of Victoria's Secret, and the same woman who accused me publicly, and it was in every newspaper in the world, accused me publicly, accused Leslie Wexner secretly. And her lawyer went over to Leslie Wexner and said to him essentially, look, the client who accused Dershowitz has also accused you, not only of that, but worse, because the client has said you made her wear Victoria's Secret baby doll lingerie, which would have destroyed the company. And the lawyer said, but the statute of limitations is 15 years old. And the other lawyer essentially said, look, we're not talking about the statute of limitations here. I'm not quoting, I'm paraphrasing. But the message he got was, do you want to have happened to Leslie Wexner what happened to Alan Dershowitz? Do you want his reputation smeared all over the world? Do you want his company would be destroyed? There are ways of resolving this outside of the statute of limitations. So I was the victim of an extortion plot. I wasn't the person from whom the money was being sought, because I don't have that kind of money, but I was the stalking horse for the extortion plot. Fortunately, I was able to prove where I was every single day during the 2 years the woman claimed that she had had sex with me. And every time she would say, oh, she had sex with me on an island in the Caribbean, I could prove I was in Israel talking to the prime minister. Maybe not the best alibi, but, you know, not so bad. When they said I was having sex with her on a ranch in New Mexico, I could show I was literally on television on CNN being interviewed in New York. So the case was totally blown out of the water. The lawyers ultimately withdrew it and admitted they were wrong. But I'm still going after the lawyers. I'm not giving up. I want those lawyers brought to justice because, let me tell you why I'm so agitated about this case. I wasn't the real victim. The real victim are real women who have been raped and sexually assaulted and who tell the truth. And when a woman makes up a story of sexual assault for financial profit, that is the worst thing because it undercuts the credibility of other real victims. And we've now discovered smoking gun emails, which the court has so far sealed, that demonstrate conclusively the frame-up. And we're trying to get them unsealed. And once that happens, if it happens, we will really go after the lawyers in a major way. But that experience made me really understand what it must feel like to be an innocent person falsely accused. Now, I was never being subjected to criminal punishment or anything. It was just always about money, but it was about my reputation. I've worked very hard for my reputation. When my wife first heard about this, she laughed. It was the most hysterical thing in the world. As I said, mimicking Woody Allen, I never had sex with an underage girl, even when I was an underage boy. I tried, but I grew up Orthodox, and so we didn't do that. But it wasn't a joke. People actually believed it until I was able to disprove it. But it made me really understand what Joseph must have felt like when Potiphar's wife accused him, or when Dreyfus must have felt like when the French establishment accused him. There are innocent people out there, and I have to remember that, and we all have to remember that when we defend people. Sure, most are guilty, but some are innocent, and it's the greatest pleasure when we have an innocent client and we can win a case on their behalf.
What a story. I'm sure if
I'm writing a book about it. People say, why are you talking about it? I talk about it because I'm a victim, and victims should speak out. Whether you're a rape victim, a sexual assault victim, or a victim of a false accusation. You have an obligation, particularly if you have access to the media, to speak out. And so I'm going to continue to speak out until laws are changed and until we can do something about both false accusations and also true accusations.
And personal experience always teaches you something more than just a theoretical thought about. And also being so busy proved beneficial. So you had the alibi.
Also being a Luddite, I don't use computers. I need the microphone. Okay. This is my calendar. It's a Harvard Cookbook. I've had a Harvard Cookbook for every month of my life since 1964, and I kept them. And it has in it every place I've ever been over the last 52 years. And it's what led me to be able to prove. Once I had the book, I was able to then go and get my cell phone records, my American Express records, my TV records, my travel records, everything. So there's some virtue in using unerasable, and I never lost a book. In 56 years, 53 years, I've never lost one of these books. So 3 cheers for old technology. Right.
Let me ask you another question about guilt and innocence. Do you inquire into your client's guilt or innocence? Can a defense attorney, in your view, better serve the interest of his client by inquiring into his actual guilt or innocence? We know that on the spectrum, there are 2 approaches. There's the lawyer who meets the client and says, don't tell me anything, I'll tell you. And then there's the defense attorney that actually wants to hear as much information. We have one very prominent defense attorney in Israel, Dan Scheinman, who recently published a book, and he advocates the more information approach. Where do you stand on this spectrum?
Okay, thanks. Okay. I advocate an intermediate approach. The last thing I would ever do... Sorry, go ahead. The last thing I would ever do in meeting a client would be to say, hi, tell me, are you guilty? It just wouldn't work. First of all, they would immediately lie to me. I've had 250 clients, 249 of them have told me they're innocent. I can't have been that lucky. So don't expect to get the truth from a client when you ask him, did you do it or didn't you do it? It's a foolish question. It's a meaningless question. You're never going to get it out of the person. But we all have tactics that we use to try to find out the truth, because you can't try a case without knowing what you're going to confront, what you're going to face. So what I say to the client is, look, assume your worst enemy would make up the worst lies about you. What is the worst thing they would ever say? And they'll reluctantly tell you some of these things and say, of course it didn't happen. Of course, in the end, that's probably closer to what happened than what you're likely to get otherwise. So I try very hard, without getting the client to be in a position to say I did it, to give me as much information. What will you expect from this witness? What will he say? What do you know about him? How can we affect his credibility? So I want to know as much as I possibly can. Now, I'm an appellate lawyer, mostly, so I don't need to know as much. I read the written record, and I appeal from a written record, but whenever I do an appeal, I also do a habeas corpus. I also challenge the conviction based on new evidence, and so I need to know what the situation is. And so I press very hard to find out. I also hire investigators, and I hire investigators to investigate my own client. Sometimes they don't like that, but I have to do it because I know the prosecution has an investigator. And I don't want the prosecution to know anything that I don't know. And the one thing I can be very proud of is every time anybody has written an article about me doing an appeal, the one thing they're impressed with is I know more about the record, I know more about the facts than anyone else in the courtroom. I have to, because I'm not making the decision, the judge is making the decision. I have to bring credibility to my argument, and the credibility comes from knowing more about the case, knowing more about the facts than anybody else does. And so I do want to find out everything I can about the client, but I don't ask them the question directly.
Let me ask you about the right to remain silent. You were involved in drafting the Supreme Court decision while we were clerking for Justice Goldberg, the very famous Supreme Court case of Escobedo, which later laid the grounds for the famous Miranda case. We all know the Miranda warning. Everybody who watches TV or cinema knows that everyone is arrested has to be warned. 4 warnings, and the first prong is that you have the right to remain silent. And my question to you is, how do you legally and ethically justify the right of someone who's been asked, is accused, suspected of something, that person may have information regarding the crime, and they are justified, they have a right to withhold that information from the authorities. If they know something, why aren't they obliged to respond?
Well, of course, the two things. First, the right to remain silent comes largely from the writings of the Rambam, Maimonides, who articulated the right to remain silent. He did it on an interesting rationale. He said that the Torah prohibits suicide, and somebody who confesses his own crime is essentially aiding in his own suicide. He also talked about people who are sick and will confess to crimes that they didn't commit. But the Rambam does begin to articulate at least a rationale. I wrote a book, must be 10 years ago, entitled, Is There a Right to Remain Silent? A provocative title. And the answer under American law is no, there is no right to remain silent. There is only a right not to have introduced in evidence against you statements you made that you had no obligation to make and the government coerced from you. How do I prove there's no right to remain silent? The government can always make you speak by giving you immunity. All they have to do is say, we're not going to use it against you. They can give you immunity. But the case that led me to conclude there's no right to remain silent was a case where the police had shot somebody and he was lying in the hospital bed wounded, and the police withheld any medication from him until he admitted that he fired the first shot. They did that because they wanted to help the policeman avoid criminal charges. They weren't going to bring charges against him. And so I asked, and the court said, the United States Supreme Court ruled that they had a perfect right to compel him to testify because they weren't going to be using the evidence against him in a criminal case. So there is no right to remain silent. There's only a right not to have coerced information used against you in a criminal case. It can be used against you in a civil case. It can be used against you to deny you a job, to deny you admission to law school. But it only can't be used against you in a criminal case. So I think it's a mischaracterization to talk about a right to remain silent. There is a right not to make statements to the police that would then be admissible against you. We're the only country in the world, really, that has even so absolute a right. And great questions have been raised about it. And of course, one of the issues is if you invoke your right not to incriminate yourself, should the jury know that? Can the fact that you raised your right be used against you? And the courts have said generally no, with some exceptions. For example, if you testify on your own behalf, then the fact that you invoked your right not to testify previously can be used against you. It's a complicated issue. It originally, under American jurisprudence, grows out of the right not to be tortured. Jefferson, when he was in Paris, was sent the draft of the Bill of Rights, which included what is now the Fifth Amendment, nor shall be compelled in any criminal case to be a witness against himself. Jefferson wrote back to Madison and said, too damn complicated. I don't understand what it means. And Jefferson was a pretty good lawyer. He said, why don't we just have nobody should be tortured or compelled to testify? And that didn't happen. So instead we have this convoluted right that nobody really understands. If you had a vote of the American public, it would go 90-10 to amend the Fifth Amendment and to require people to testify. You know, under European law, and I think it's the same under Israeli law, you cannot be prosecuted for lying in your own defense. How do I know that? Because I was a consultant to the Israeli government on the Demyanjuk case. And when the Supreme Court of Israel reversed the conviction of Demyanjuk, who, if he wasn't Ivan the Terrible, was certainly another terrible Ivan. When that conviction was reversed, I called the then state attorney, Dory Banish, ultimately the president of the Supreme Court, and said, well, it's an open and shut case for perjury. You can, of course, prosecute him for perjury because he said he was in this camp, and the documentary evidence that got him acquitted showed he was in this camp. It's open and shut. Just show his testimony, lay down the record that he put in. And she laughed at me. She says, what are you talking about? We don't prosecute people for perjury for testifying falsely on their own behalf. Britain, Europe, most countries don't. In the United States, we vigorously prosecute people. You can even be prosecuted if a policeman stops you and says, or an FBI agent stops you and said, did you murder that person? And you say, me? No. That's a crime. That's a crime. It's a crime in America to deny an accusation against you, even not under oath, if you're speaking to the FBI or a police official. So what we give with one hand on the right not to incriminate yourself, we take back with the other hand by very onerously making sure that if you do say anything, it darn well better be the truth or you're going to go to jail for having lied. Martha Stewart, many of you know who she is, she didn't go to jail for having insider trading on stock. She went to jail for testifying falsely that she didn't have insider trading on stock. And so that's often the way we put people in jail. It's the cover-up that often gets you rather than the original crime.
That's very interesting, and it teaches us that you cannot look at one area of the law, but you have to look at the whole system when you compare, because in our system, for example, we have a right not to testify, or defendants have a right to testify, but it's very rarely used because you will lose the case. It is prejudicial against you. I know a handful of maybe 5 cases of people got acquitted without testifying. It's very rare to take the decision not to testify your client or to advise your client to make that decision. And you can also use the silence of, or the prosecution can also use the silence of the suspect in the police in the trial, with some limitations, but it is definitely the judge knows about it, and it can be used.
It's so interesting because it shows you how culture affects rights. In the United States, you would think that juries would hold it against a defendant for not testifying, but everybody's seen television. Everybody knows that you have a right not to testify. It's part of the American culture, and so juries don't. Prosecutors always try to figure out a way of trying to get the jury to infer guilt from the silence of the defendant. The famous funny story about it, a Jewish man, old Jewish man, is brought in front of a judge on charges of murder. And he says to the judge, "I did it in self-defense. I did it in self-defense." And the judge says, "Well, why didn't you tell the police you did it in self-defense?" He says, "I couldn't talk. I was handcuffed." So we know how Jews talk with their hands. So in the United States, you can. Juries do sometimes infer guilt, but the culture is such that they don't. Look, one of the first law review articles I ever wrote, I called the balloon theory of criminal justice, and I made the point that you've just made, that you can't understand any part of the criminal justice system without understanding every part of it. That when you have a balloon and you press one side of it and the air comes out, it moves to the other side. And so, in fact, legal systems, criminal justice systems, are more similar than they are different when you look at them not from a legal point of view, but from a sociological or criminological point of view. You see many, many more similarities, and gaps that are created in one part of the system are filled by another part of the system. For example, we had deinstitutionalization in the United States in the 1980s. We took hundreds of thousands of people from mental hospitals and released them. They weren't released. They were brought back into the system through the criminal justice system. Many of them ended up in jail for minor crimes. And so if you look at the total of the balloon of how many people were confined, you didn't see an enormous difference. But if you looked at only one part of the system, we said, my God, we've had deinstitutionalization. But deinstitutionalization of the mentally ill resulted in increased institutionalization of petty criminals.
I see there are a few of my friends from the Public Defender's Office here. Can I ask you a question about public defense? The very well-known decision of the United States Supreme Court, Gideon versus Wainwright. A great story. This is the decision where the Supreme Court ruled that everyone accused of a felony has the right for counsel funded by the state. To be represented by counsel funded by the state, and this became later a book, a great book, Gideon's Trumpet. I believe you wrote an introduction to that book, and then later it became a movie because it's such a great story. Gideon was accused and was convicted without the aid of defense attorney. He was sent to prison, and then from the prison he wrote a handwritten petition to the Supreme Court, and the Supreme Court actually heard the case, listened to him, reversed his conviction. He got a new trial, got acquitted, but also changed American law, and the right to counsel was announced as applies to all states. But, so it's a great story, Hollywood movie is almost inevitable. But 50 years later, there are many commentators who point to the gap between the promise of Gideon and the reality of defense for poor people, indigent people in the United States. Many states don't have public defender system. They still use the court-appointed lawyers system, which is not that good in terms of quality. Many public defender offices are underfunded. Their caseload is extreme. So many poor defendants don't get, those who cannot have Alan Dershowitz or the like as their defense attorneys, and they're not lucky enough that you'll take their cases pro bono, don't get adequate defense. And what do you think about it, and what are the pitfalls that you think that we should avoid regarding the right to counsel?
Well, Gideon versus Wainwright only applied, really, it's supposed to apply all over the country, but it applied only in a few states where public defender offices were created, in the federal system where public defender offices, and public defender offices, for the most part, in the United States are quite good. They're very good in terms of the lawyers. They're not so good in terms of the investigative resources allocated. But let me just give you an example from my career and how I had to be candid with the court about a situation. So I had a client, an African-American man, who was sitting on the porch whittling some wood, and his nephew and a friend drove by in a car and said, "Come with us for a ride." And he went in the car. He didn't realize the car had just been used to rob a liquor store. They were three blacks in the car. Two state troopers came and stopped the car. There was a struggle over a gun, and one of the young men took out the gun and shot and killed the state trooper. The two young men who had experience in the criminal justice system copped a plea and testified against my client, the older man who was mentally retarded and didn't know anything really about lawyers. But his family put together a few dollars, and they hired a local lawyer, the former head of the Ku Klux Klan, named Piggy Parrish, appropriate name. They thought that by hiring a Klansman and a white, establishment guy, maybe they can get a break. Well, Piggy Parrish never even went and interviewed anybody in the black community. He said, "I don't go in that neighborhood." And halfway through the trial, he fell asleep. And he slept through the testimony of one of the major witnesses against the defendant. And of course, when we were asked, did his falling asleep affect the trial, I had to acknowledge, Your Honor, the hour that he was asleep was his finest hour in that court. It was the only hour he didn't do damage to the client. This guy argued in front of the jury. Ladies and gentlemen of the jury, you heard my client say he was beat up by white state troopers after he shot one of them. I don't know why you should believe him. I don't. This is his own client. He's saying you shouldn't believe him. It was a horrible, horrible situation, and unfortunately representative of the of what happens in many southern states, where courts appoint drunks, drug addicts, formerly disbarred lawyers, lawyers who are 80 years old, to represent people on death row. Give them $1,000 for the whole case. That's their fee. $1,000 for the case. New York lawyers charge $1,000 an hour. These guys get $1,000 for a 2-month-long case. Imagine the kind of lawyer who would make a living taking 4 cases a year for $1,000. So the promise of Gideon has been broken repeatedly, and the only answer is public defender systems where there's 1-to-1 funding, where every dollar given to a prosecutor must be given to the defense attorney. I have been arguing for that as a constitutional right. So far, we've gotten courts not to accept that, but there has to be, if you have equal justice, you have to have the same resources available to the defense as you do for the prosecution. It's a dream. I don't think it will be accomplished in my lifetime, but I really do think, in the end, it's the only solution to the system. And, if you don't want people to be convicted not based on whether they did it, but based on their availability of counsel or access to money, you have to create equality in the system. They did studies of who gets the death penalty, and the one thing they found doesn't explain who gets the death penalty is the heinousness or the seriousness of the crime. I mentioned one factor, the race of the victim, the race of the defendant, but also the nature and quality of the lawyer. Lawyers like us don't have people sentenced to death. We may lose cases, but we don't have lawyers, clients sentenced to death. People today in America are sentenced to death almost exclusively if they have incompetent or near incompetent lawyers. So Gideon versus Wainwright is a great motion picture, great book, but the result was not nearly what one could hope for.
I wouldn't argue with you about the need for parity between prosecution and public defense. Not quite. We have a good system, a nationwide public defender system, which is funded adequately, but there's no parity with the prosecution. We're getting close to concluding. I'd like to ask you, I think in the introduction, Professor Hannes mentioned the amazing number of cases that you have won. But every defense attorney, surely every defense attorney has some cases that they lost. And my question to you is, what is the one case that you lost that stings more than others? Please.
Well, when I wrote my first book, The Best Defense, which is, I guess, the title of this, I wrote it back in 1982. I'll never forget that year because it was the year I met my wife. And when I gave my wife the book, she said, look, you have two choices. I can either read your book or go out with you, but I can't do both. So you know what I opted for. In any event, the publisher was amazed that in the book, although I've won a much higher percentage of my cases, in the book, for every case I won, I have a case I lost. And I think you learn as much from what you've lost as from what you've won. So I lay out the cases I've lost, I lay out the reasons I lost them, and I lay out a theory too. I don't think you should judge lawyers by their won and lost records, because like diving in the Olympics, you should judge them by the difficulty of the case. And some lawyers win all the time because they pick only easy cases or cases of obviously innocent defendants. I have a lawyer friend of mine who was a public defender. He lost 56 cases in a row, and he was one of the best lawyers I ever encountered. But he just had no winning cases. And so for me, I don't know. I haven't lost a death penalty case, so I can't say. If I had lost a death penalty case, that would obviously be first on my list. I guess maybe the Mike Tyson case. I represented Mike Tyson, the boxing champion, and we lost that case on a 2-2 vote by the Court of Appeals. And the reason we lost it is because the fifth judge on the Court of Appeals of the state recused himself. And he recused himself because his wife came over to me at a law school reunion and tapped me on the shoulder and said, Alan, I just need to tell you that that New York approaches to cases don't work in Indiana. I said, who are you? She said, I'm the wife of the Chief Justice. I said, well, I can't be talking to you. Please, I don't want to hear anything further. He used that as an excuse because he himself had been accused of sexual misconduct when he was on the bench. And he didn't want that to again come up. And so he decided to recuse himself, and we lost the case on a 2-2 vote. Very, very interesting legal issue. What happened in the case is there were two witnesses who were excluded from the court, even though they saw the victim and the defendant walk into a hotel room, the hotel together, holding hands and kissing, and she had testified that she was repulsed by him and never wanted to be close to him. I don't know to this day whether Mike Tyson was guilty or innocent. I don't know that about many of my clients. I think in these areas of consent, often there are perceptual differences. I'm fairly sure that the victim in the case believed she didn't consent, and the alleged perpetrator may well believe erroneously that she did consent. Look, a lot of men don't understand what no means, and it's a terrible, terrible, terrible thing. They think they're so irresistible that no means yes, and the law has to, of course, change to recognize that. No must absolutely, under all circumstances, mean no. I teach my students in criminal law, by the way, it's an interesting way of teaching this subject, that there are two rules. One, when in doubt, if you're in a sexual encounter, and I'm teaching, 25-year-old students, when you're in a sexual encounter, if you have any doubt whatsoever about whether you have full and complete consent, do not do it. I say better 10 potentially good sexual encounters not occur than one non-consented sexual encounter occurred. Always err on the side. Then if you're on a jury, you have to reverse it. Better 10 guilty go free than one innocent be wrongly confined. So it depends where you are. If you're making the decision about whether to have sex, you apply one rule, and if you're making the decision in the same case about whether there was consent, you have to apply a second rule, and it's very complicated. Kahneman and Tversky, you all know Kahneman's work here, and Tversky, two Israelis. I actually was planning to write a book. Amos Tversky was a friend of mine. We were at the Center of Advanced Study of Behavioral Sciences together in the early 1970s, and we had agreed to write a book on the meaning of proof beyond a reasonable doubt, because as you know, their work is brilliant in explaining the psychology of how humans deal with probabilistic thinking and how difficult it is for particularly a jury to analyze a case based on proof beyond a reasonable doubt. So we were going to write the book, and unfortunately it never happened, and then tragically Amos got sick and died at a very young age, and Kahneman got the Nobel Prize, but really it was a Nobel Prize for the work of both of them. Look, my final parting words to you, because I think we're coming to an end, is that law is very complicated, very nuanced. There are no simple answers. Almost every right has a cost attached to it. Almost every change in the system will bring about other changes in the system, some good, some bad. For example, take again in the rape case, I was very instrumental in trying to get the rules changed that you don't need corroboration. It's outrageous that only in rape cases should you require that the testimony of the woman be corroborated. Women have to be believed in the same way that men are believed. You can't have sexist distinctions like that. But there's no doubt that when you eliminate the corroboration requirement, you're going to get at least a small number of innocent people who would previously have been acquitted now being convicted. Every good rule, every good change has some negative consequences. And if you want to be a criminal defense lawyer, you have to learn to live with moral ambiguity. You have to learn to live with uncertainty. You have to learn to live with some of the questions we've raised here today. But I have to tell you, there's no more exciting job in the world than being the only person standing between you, between your client, and between imprisonment, or in where I practice law, death. And so if you want a challenging, incredibly difficult, interesting career, being a criminal defense lawyer is certainly high on the list of things you should consider doing.
This is a terrific ending for a very interesting and fun talk that we've had. And Professor Hannes, please.
Just a couple of more minutes. Thanks, Alan and Yoav, for a marvelous evening. And let me invite Danny Grossman to say a few words and tell you how you can be in touch with Professor Dershowitz.
For those people who don't know me, I'm Danny Grossman. I am not a lawyer, although I did take Criminal Law 101 with Alan when I was a Wexner Fellow at Harvard. And but the one thing I want to mention, what you convinced everyone at Harvard, all of the students in Criminal Law 101, with the OJ, we were there for the closing arguments. You used a terrific analogy. Here it was kind of 50-50 when you used about the sock, this and that. With us, you said one analogy. You said, who here, let's say, forget that, you're in a restaurant and you're eating spaghetti. And you find a cockroach in the spaghetti. Now I want to raise your hands. Who would pick up the cockroach, put it on the side, and continue eating? Thank you. Who would order a new bowl of spaghetti?
That was Johnny Cochran's argument. So
but it was okay, but it was fairly good. The cockroach and the spaghetti. But I'll just one other quick thing. The other thing, I was actually in Alan's office when Barry Scheck called with the evidence. Remember that he called? It was amazing. Oh, he said, wow. Get OJ. OJ, listen, we just got the labs back. We have good news and bad news. And OJ said, Alan, I'm a football player. I'm a tough guy. I busted my knees. I went back. Give me the bad news first. He says, well, the blood on the glove, blood on the sock, all that blood. It's your blood. You're the killer. Closed case. And you're, oh my God, what could possibly be the good news? He says, your cholesterol is only 120. You know, no, that's fiction. Okay, that's fiction. But what's not fictional, however, and this is the reason I wanted to give this all to you. Obviously, when we talked with Shai, and I wanted to see, again, one more thing for Shai, who actually gave it up for Shai, of course, with the dean, and also Hannes, but Shai really worked hard in conceptualizing this whole program, and we wanted to have Q&A from the students, however, we don't have time. And, Brother Yoav, you actually gave me the drive to go out and commit a crime so I could have a public defender. But for those of you who want to keep up contact and have questions, and we want this whole thing to be interactive, to keep on going, Professor Dershowitz, you know, is Israel's greatest defender. And several years ago, instead of just talking about it, for years everyone said what we need is good hasbara, good this. He actually helped us launch a thing called ILTV, which is a good, strong English language news program. It just got launched about a year ago, and it has the news 3 times a day in beautiful English with phenomenal anchor people, and we have a program called One-on-One with Alan Dershowitz. So if you can't remember, it's called ILTV.tv, which is pretty easy to remember. Just go one-on-one. By the way, it's taken from basketball. He's a great ball player. So what you would do, all you got to do, go to ILTV.tv. Okay, you'll see exactly what to do. It says, take your cell phone, make a 30-second selfie, ask a question, we'll put it on the program, and then when you get your question and answer, you can share it with all your friends on Facebook, Instagram, and everything. So you have something real tachlis to take home from today's lecture, which you can actually do. Thank you very much again, Professor Dershowitz and everyone.
Thank you again, and thank you to the audience.